Sorry, DPR. Don't take some of your action, please. What's that? Sorry for that.
Good morning. No worries.
Good morning.
This is some written testimony, which I don't intend to read, so I'm going to hand you. It has a lot of footnotes. We're all lawyers here, so the backup for my spoken testimony will be...
There's only one lawyer here.
Oh, okay. Okay. Well, I've given you a lot of footnotes.
Oh,
Oh,
here's another one. Okay, thanks.
thank you.
And these are exhibits which I've been asked to hand up that are the background studies that are cited in some of the...
Are there 6 of them?
These notebooks, there are 3. So if there need to be more, I'm sure we
Well,
can arrange to get
okay,
more.
the-
Yeah, I think it was a paper saving.
Well, I had a memo from someone this morning saying there were 6 background. That's all I was. If there
I'm
aren't,
not too
there aren't.
sure. I didn't prepare the notebooks.
No problem.
So, yeah.
Okay.
Okay, so good morning. I'm Kathryn Tucker. I'm Director of Legal Affairs for Compassionate Choices, and I thank you for inviting me. I want to tell you a little bit about Compassionate Choices in case you don't know our work. We're a national nonprofit with members in all 50 states, and we work broadly to promote improved end-of-life care. We are in the forefront of efforts nationwide to ensure that patients get good pain and symptom management. We've been involved in efforts to ensure that patients approaching end of life receive comprehensive counseling about end-of-life options. We are advocates that patient wishes be respected, so that patients, for example, who execute advance directives, those directives should be honored. We've been in the forefront of bringing accountability where directives are not honored or where patients who are dying do not get adequate pain and symptom management. We have been advocates for expanding end-of-life choice to include things such as palliative sedation, and we also are advocates to expand choice to include aided dying, which is what is at issue in the Death with Dignity measure that is in front of you. So we're not a single issue organization. We are advocates for comprehensive improvement in end-of-life care. My involvement with the issue of aid and dying dates back to 1990 when Washington State was the first state to move in the direction of having legislation enacted. It was through an initiative process. It didn't pass there in that session. It did recently pass in 2008. I've been involved with the effort to enact the Oregon Death with Dignity bill, which, as you know, was enacted also by initiative in 1994. And since then have been involved with defense of the Dignity Act in Oregon, including in the case that went to the U.S. Supreme Court involving the U.S. Department of Justice, where the Oregon statute was upheld. I've also brought a number of cases to the U.S. Supreme Court in which the question of whether the choice for aid and dying is a matter of liberty or equal protection under the United States Constitution. What the Supreme Court said was, we won't extend that right today, we may do it in the future, but for the moment we invite the states to grapple with this issue. And so, as you know, several states have done so. And so I will spend most of my time talking about what the experience has been in Oregon, since Oregon has now more than 15 years of experience with a statutory framework governing the practice of aid and dying. This committee stands in a landscape rich with data. When the cases that I argued in front of the United States Supreme Court were heard in 1997, there was no data. There was no open practice of aid and dying anywhere in the United States. And so when opponents stepped forward, as many did today, and raised many of those same arguments that you just heard this morning, there was no data whatsoever with which to respond to them. So the questions about, would this put patients at risk? Would this put persons with disabilities at risk? Would this somehow adversely impact the doctor-patient relationship? That kind of argument could not be addressed with any evidence. it was a very difficult place in which to argue. And that's why, if you look to the opinion of Justice Souter, in those cases, he said he couldn't find federal constitutional protection at that time because of the substantiality of the factual dispute. The factual dispute is over. We have 15 years of data from Oregon. It's been reported. It's been examined. It's not only been examined, but it has then been the subject of extensive evidence-based review by leading medical and health professional societies who've looked at the data and concluded no risk, important benefits, this is an option that should be available. So let me spend a few minutes talking about what the experience in Oregon has been. There have been a lot of studies that looked at the question whether persons with disabilities, and the last speaker, the chair is still warm, was speaking to the concerns of persons with disabilities. Careful investigation of whether persons with disabilities have been put at risk. Finding there is no evidence that that population is put at risk. We haven't seen any harm to any populations, including that special population. We haven't seen that this is pushed upon persons that lack insurance. We haven't seen that this is an option that's pushed upon persons who are uneducated. These were the contentions that were made before the Oregon law was enacted. We're still hearing the same arguments, but the data doesn't support it. What the data does support is that the choice for aid in dying is rare. Patients don't rush to use it. One of the reasons why you see in the official reports that there is carryover, that sometimes a patient gets a prescription in 1 year, but does live longer than was anticipated. Patients don't rush to use their medication. They're comforted to have it. They live as long as they can. Many of them, and here's a really interesting aspect of the data, about 1/3 of the patients who get the prescription never take it. They go on to die of the underlying disease. They're tremendously comforted to have it. So there's no rush to take the medication. It's rarely taken. It offers tremendous comfort to the patients who can receive it. So what we have with the 15 years of data is a tremendous body of literature that examines the data and reaches the conclusions that I've just shared in 30 seconds. So I invite you, of course, to examine the data and the many, many, many studies that look at it. A tremendous consensus has emerged about this data and what it tells us about who chooses this and why. Most all of the patients are dying of cancer. The next largest group is dying of ALS. They are overwhelmingly enrolled in hospice, 97%. What has been seen in Oregon is when this option became available, it raised the floor for better end-of-life care for all patients. Why? Because physicians in huge numbers went about the business of ensuring that they knew how to treat pain and symptoms. So they enrolled in larger numbers in courses, continuing education on how to treat pain and symptoms. That raises the floor for good end-of-life care for every patient in the state of Oregon. We're seeing the same thing in Washington, by the way, as well. We saw prescriptions for strong pain medications go up in that state. Those are regulated, of course. It's easy to search and see that the prescribing of strong pain medications increased. Nobody wants a patient to choose aid in dying because they're not having good, effective pain and symptom management. One of the other things that we saw, and I know you heard a hospice speaker this morning, referrals to hospice skyrocketed. Not only that, the referrals happened earlier. You know, the tragedy in hospice is that so often patients are referred late and they're in crisis and there isn't the opportunity for the patient to really be stabilized and have the benefit of comprehensive pain, symptoms, psychosocial care that hospice is good at providing. So hospice enrollment skyrocketed, and I think you heard from the former director of the Oregon Hospice, who no doubt went through that with you in some detail. So hospice in Oregon now is quite supportive of the Dignity Act because it did increase the ability of hospice to do their excellent work. So we've seen these improvements across the board that benefit all patients approaching end of life due to terminal illness when aid in dying is an option that's available. It's an option to expand choice. So there are many choices that terminally ill patients can already make. So for example, law and medicine in all 50 states supports patients being able to refuse unwanted medical treatment. And not only can they refuse it on the front end, but they can invite medical behavior to withdraw that if they've accepted it. So for example, a patient who has had a cardiac device implanted that keeps them alive can direct that that device be deactivated. That precipitates death, and that is permissible. Patient, same thing with a ventilator. If a patient's been put on a ventilator, can direct the withdrawal. That precipitates death. The patient is empowered to make that choice. Palliative sedation. That actually is an intervention that was first recognized as a matter of law by the United States Supreme Court in the Glucksberg and Quill cases, which were the cases I brought before the court in 1997. It's now been very much embraced in clinical practice guidelines in the practice of medicine. Patients who have refractory pain and symptoms can ask to be sedated to unconsciousness with food and fluid withheld until death arrives. That way they are unaware of the burden of suffering that they're exposed to. That's a good choice for some patients, and it should be available, and it is available. Aid in dying is a different choice. For some patients, that would be a more desirable choice because it doesn't involve the 7 to 10 or 14 days of lingering in an unconscious state before death arrives. So what this measure before you is about is adding one additional choice to patients who have an array of choices and empowering them to make the choice that is most consistent with their values and beliefs, because that's obviously a very personal matter. We heard something from the hospice speaker this morning I just wanted to comment on, and she raised the question about what does it mean to survivors of the patient if a patient chooses aid in dying. One of the wonderful things about medical researchers is they are always inventing really interesting new studies. There is a study that looked at this question exactly, and the study said, well, we know from a lot of medical literature that when someone commits suicide, which of course is very different than the choice of a dying patient for peaceful death, but when someone commits traditional suicide, they've lost their job, they have financial worries, they're distraught, and they shoot themselves. It is well known that survivors have adverse mental health effects, and they bear that burden the rest of their lives. These researchers wanted to know, do survivors of patients who choose aid in dying experience any of those kinds of adverse mental health effects? And the answer was no. The survivors of patients who are empowered to choose aid in dying are more able to deal with grief. They feel they supported their loved one in having their wishes respected and being able to achieve a death that was consistent with that individual's values and beliefs. And that's hugely important, not only to the patient, but to those who love the patient. So I'm really looking forward to taking questions, but I wanted to close by sharing that this great body of data, as I mentioned, has been closely examined by many medical and health policy groups, and I've given you a collection of a number of them that have, after a careful evidence-based review of all of the data and all of this abundance of study, have concluded that the option of aid in dying does not put patients at risk, and it improves end-of-life care, and it provides an important end-of-life benefit. So for example, the American Public Health Association, the nation's oldest and largest organization of professionals dedicated to protecting the nation's health, has considered the Oregon data. And actually, I was involved in the policy process of that adoption, and they considered it in a highly unusual way. Normally, at the APHA, it's a one-year process. Because of the concerns presented by the disability section of the APHA, which is a very powerful section within the APHA, they set it over for a 2-year hearing. So 2 years of evidence-based review by the nation's leading epidemiologists and scientists and health policy professionals. And they concluded with a policy, it's in the book, supportive of aid in dying. So I hope you'll take a look at what has been endorsed by these many medical and health policy groups. And I'll really just close with a comment that I think brings this into focus for what is in front of you, and that's a comment by philosopher Ronald Dworkin, who said, "We live our whole lives in the shadow of death. We die in the shadow of our whole lives. We worry about the effect of life's last stage on the character of life as a whole, as we might worry about the effect of a play's last scene or a poem's last stanza on the entire creative work. Supporting enactment of the Dignity Act will empower each individual Vermonter to decide for themselves how to cross life's last stage." So I thank you for hearing me, and I welcome opportunity to respond to questions.
I have a number of questions, and I'm sure other committee members do as well, but on page, I guess it's page 5, footnote number 11, says, this is Arthur Shinn et al. No empirical evidence of the slippery slope in Oregon. You spoke to the slippery slope. That is not. More potential for a slide in the Netherlands. Do you have any information that you could share with us on why it's not a slippery slope in Oregon, but it has potential for a slide in the Netherlands? It's an interesting comment.
Having lived in Oregon, I know that people there really like it when you say Oregon. Just sharing that with you, and I'll share a little funny story of a federal judge. Well, a federal judge who was hearing the case brought by the U.S. Attorney General looked across the table at the U.S. Attorney who had flown out from Washington, D.C., who said Oregon, and he said, "It's Oregon." And he did the little gun thing. I know. Anyway, he did rule against that attorney.
Well, how do you pronounce Worcester?
Yeah. You know, the studies that look at Oregon and the Netherlands, I think, are really tricky because, of course, the Netherlands, hugely different culture. In that system,
They legalized marijuana, I think.
well, not only that, but in the Netherlands, they also permit physicians to administer the life-ending medication. So they support euthanasia. I think it's really hard to extrapolate from the Netherlands. I think the good thing is it isn't necessary to do that because we have 15 years of data from the state of Oregon. You know, when the U.S. Supreme Court in '97 said, let's invite the states to grapple with this issue, that's a classic jurisprudential procedure, and it lets other states watch and learn. And the beautiful thing about what the Supreme Court did in inviting the laboratory of the states is the laboratory opened almost immediately after the Supreme Court's decision, because Oregon's law became implemented beginning in 1998, just after the decisions in '97. That laboratory has served its purpose. It has created this vast body of data, very rich. It's in the notebooks. You can learn pretty much anything you want to know. What was the age? Was the person married? What was the underlying condition? What was their education level? All of this information, how long was their relationship with the physician? How many minutes between taking the medication and unconsciousness? How many minutes between unconsciousness and death? The data is rich, so we don't need to look to the Netherlands. And I would suggest it's confusing to do so for the reasons I mentioned.
Second question is, I was struck by the use of the terminology, and that's one of the debates that's going on here in Vermont. Is it assisted suicide? Is it physician-assisted prescription death? What is it?
Right.
And you use the term compassionate choices.
Well, Compassionate Choices is the name of my organization.
Oh, okay.
Yeah.
And other death with dignity, other views, end-of-life choices.
Right.
But yet, most of the footnotes seem to suggest it's assisted suicide. So, what is it?
Yeah, well, I welcome the question. I think words matter. I think language matters. In the past, commonly, the term assisted suicide was used. Older literature, you frequently see that. Today, in modern time, in this moment, the term assisted suicide is used by opponents exclusively. Those who support this choice and are not necessarily advocates for it call this practice aid in dying. And that terminology has been adopted by the American Public Health Association and many other medical groups. The term death with dignity is used by proponents. It's a very sympathetic and appealing term, and I say it probably is at the pole opposite assisted suicide on the other side. The term that has been embraced as value neutral and accurate is aid in dying, and that refers to a very specific medical practice. It is the act of a physician writing a prescription for medication for a mentally competent, terminally ill patient, which the patient may self-administer to bring about a peaceful death. That's a big mouthful. That's why the term aid in dying is now accepted as a medical term of art. So what the bill in front of you would permit, what the Vermont Death with Dignity Act would permit, would be the practice of aid in dying in Vermont.
Any other folks? Senator White, your question first, and Senator Ash, and then Senator Beth.
I apologize for not being here. I just wonder if you could address one of the issues that has been brought up to us, that by doing this we are somehow devaluing the life of people with disabilities, and that it's a cultural change. And has that been borne out in Oregon in any way?
I think that whenever a terminally ill person is empowered with choices, we honor that person. Whether that person had a pre-existing disability before they became terminally ill or not. Aid in dying is not available for persons with disabilities per se. So if you are in a wheelchair because you've had spinal cord injury, if you were born with some disabilities, cerebral palsy or some such, you are not eligible for aid in dying. The only people eligible for aid in dying are people dying of terminal illnesses. Now, some of those people may have also been in a wheelchair. Should we exclude them from the choice of aid in dying because they've had a disability? I don't think so. And in fact, when the APHA policy was going through the American Public Health Association, that actually was one of the possible amendments, is that there would be exclusion of persons who had pre-existing disabilities from that. The disability section, of course, rose up against that because they didn't want to be denied a choice that other citizens would have. I think it empowers people, whether they had a disability or not, when they have an additional choice.
I guess just a follow-up to that is, has the disability community in Oregon felt, do you know if they as a disability community, I mean,
right. We do have a statement, an affidavit from the director of Oregon Disability Rights, where for all of the years that he held that job, which was basically the first 10 years of the Oregon Death with Dignity Act, he didn't know of a single instance of a person with a disability having any opposition to the measure, and so we have that testimony, which we can make available to you, and I think it may be in one of the notebooks. Robert June Deaf was the witness, the affiant. We have a really nice video that was done by Compassionate Choices of Oregon, where it interviews people with a whole range of disabilities in Oregon and asks them, do they support the law? And we could share that video with the committee. The answer was they are not offended by it, and they're glad to know that it's an option should they have a terminal illness and should they find their dying process unbearable. I mean, again, I think the reality, and also borne out by the Oregon data, no one rushes to make use of this law. And it really is for patients who find themselves trapped in a dying process that they find unbearable. Yes, we can do a lot of really wonderful things with hospice, and I think it is a beautiful thing that there's such enormous enrollment in hospice in Oregon. You don't see that in states where this option is not openly available. That's been a silver lining. But it is recognized across the medical community that there's a fraction of dying patients who, even with excellent pain and symptom management, do not get relief. And for that fraction, yes, they can choose palliative sedation. Not everyone thinks that choice is right for them, because it does involve perhaps several weeks of lingering unconscious while your loved ones stand at your bedside. And for some people, that seems barbaric.
Something like that.
I've got a couple of legal questions for you. Is Oregon and Washington both 18 and above?
Yes, so yeah, I heard a comment about that.
What's the rationale for
Mhm.
someone who has the same illness? If they're a day before turning 18 and the day after turning 18, one gets to make the choice, the other one doesn't get to make the choice.
Right.
Is it simply because they're treated as incompetent?
Well, they're treated as children, and so, you know, the Oregon and Washington measures speak in terms of adults, and we typically think of an adult as someone who has reached that age of 18. For people who are under the age of 18, we look to the parents to make medical decisions for them. Aid in dying is a choice that we believe should be made by the individual, no one else. And so aid in dying, for example, is not something that can ever be chosen by a surrogate decision maker. And that's really important for everyone to know. We do empower surrogate decision makers to make decisions not only for children, but for any person who's lost the ability to make their wishes known. So it is very common that we recommend that people sign durable power of attorney for healthcare, which says, if I can't make my healthcare decisions, I want my husband or my daughter or my sister to make my healthcare decisions for me. We permit that in all 50 states, and those decisions can include decisions that precipitate death, removing a ventilator, removing a feeding tube. For aid in dying, where this society appears to be, is that it's important to reserve the decision to the individual. We want to know that this is a personal choice.
I understand. I think you're going a little far afield from my question. What my concern is, I don't know whether you've faced any situations in either state where someone who is under the age of 18 has either been appointed a guardian or their parents are making decisions for them. I'm assuming from your statement that's not allowed.
I haven't, it's not allowed, and I haven't seen it happen. If you look at the data, and here's one of the things, I mean, again, the data is very rich. It does show you the ages of the people choosing to use the Dignity Act, and it's almost invariably people of advanced years because they are most commonly people confronted by terminal illness.
Let me ask, can I?
Yeah,
Go ahead.
I know what the data says, but the critical question is, have you ever been actually faced with a situation where somebody under 18 wants to take advantage of it?
No,
Okay.
haven't heard it.
I don't know if you wanted to follow up with that.
Well, to follow up with what we heard from a lot of people in the public hearing was if they had Alzheimer's, they want this choice.
Right,
And no one had the heart to tell them that the bill wouldn't cover them.
right.
Has that been discussed in other states? How,
Right.
what to do about people who, you know, may choose to write a directive that they don't want anything?
Right.
I don't know if it's a follow-up to your question or not.
Well, right.
It's a
I mean,
group that I wonder.
yeah.
And as we age, we start to think more about it.
Right. Point well taken. I mean, I hear that all the time because I do a lot of community meetings around the country and have done for the last 20 years. And you always hear that question. So it's a great question. This bill would not extend to persons who have had impaired decision-making. So if someone has Alzheimer's and their decision-making has become impaired, they could not make this choice. Now, persons with Alzheimer's can sign advance directives that would say things like, if I reach a progressive stage where I cannot recognize people, I cannot engage meaningfully in activities, I want all medications withheld, and I want all food and fluid withheld. So they can anticipate a stage of Alzheimer's where their wish for a relatively speedy death could be respected through the withholding of medication and the withholding of food and fluid.
That sounds a little unfair.
Well,
I mean,
I
you
think
say
again,
you're advocating for people who are in the throes, you know, within 6 months of death, diagnosed, et cetera, and then you say to these people, this whole group of people who have have Alzheimer's, well, you can starve yourself. I mean, that seems like the same testimony we heard about why we should pass the bill, because that was an awful thing to put people through.
Well,
I think it's kind of interesting that the proponent, I don't want to go there.
Well, I do want to say the choice of foregoing food and fluid, which in the medical literature is referred to as VSED, it's well accepted in medicine. That stands for voluntarily stopping eating and drinking. The choice for VSED is a legitimate choice. Any citizen can choose that in all of the 50 states. It is supported in law and medicine. Medicine has palliative measures that support patients in the interim until death arrives. And for some patients, that choice will be right for them. It will be consistent with their values and beliefs. For other patients, it's not appealing. So again, I mean, as an advocate for patient choice, which I am, I think it belongs on the array of end-of-life options. It won't be for everyone.
Senator, I'm sorry.
Two more questions. Suicide is not illegal in Vermont. Being an accessory to murder is. I don't know if you were here when I asked this question earlier, but what happens in a situation where a person who has that 6-month termination designation is prescribed the medications necessary to do the act, but outlives the time period, and let's say a year, 2 years goes by. They're in a room full of people, and sure, nobody's ever going to help that person self-administer the drug, but we all know that's going to happen. We all know that physicians actually overdose morphine on occasions out of compassion. The nutshell question is, have you ever seen a situation in either state where a prosecutor has chosen to prosecute individuals who may have been in a situation where they decided to help the person self-administer?
No. Hasn't arisen, but let me just address that scenario because the scenario happens all the time. I mean, if you look at the Oregon data, what you will see is that every year there are some number of carryovers, meaning, and if you look at the data, it also, I believe, shows the time between when the prescription is written and when the death occurs, if the patient ingests the medication and the death is the result of ingestion. It does happen that more than 6 months goes by. Now again, is that good or bad? I mean, I think it speaks to the fact that no one rushes to this choice. People cling to life. Terminally ill people cling to life, and so they wait, and they wait until their suffering is unbearable. And by the way, you know, we heard a lot about pain. If you look at the Oregon data, pain is pretty far down the list of the reasons why people choose aid in dying. It's never a single reason. It's typically a cumulative burden, and the burden is comprised of pain being one component, but the other components that are actually higher on the list for more patients, loss of autonomy, loss of ability to engage in activities that are meaningful to the individual. These concerns, they're trapped in bed, they have debilitating fatigue, they can't speak to people, they can't get up, they can't move around, they have nausea, they have open wounds. They have this cumulative array of burdens that brings them to decide that their suffering is intolerable. So some of them carry over into another year, meaning that they have outlived the 6 months. They are still eligible. They have the prescription, they're able to take it. I've never heard of a single investigation in either Washington or Oregon, or either in Montana, where aid in dying is openly available under a court decision, or Hawaii, where it's available under best practices with no statutory governance. I haven't heard of any investigation of a person who was present when the patient ingested medication if it happened to be outside of a 6-month window.
That answers the question. One last question. Montana situation you brought up is based according to your footnote on the Baxter versus Montana decision from 2009. My understanding of that case, it's been a while since I read it, but my understanding of the case is it turned on a provision of the Montana Constitution, which is very specific.
No, actually not. The lower court made a constitutional ruling. I was the lawyer in Baxter, so I can speak from having litigated the case. We had a combination of 2 constitutional claims. Montana has a very unusual constitution, as you point out, because not only does it have an explicit provision for privacy, which not every state has, but it has what only Montana has, and that's a provision for dignity. We made a privacy and dignity argument as well as a statutory argument. I would say 99% of the briefing and the argument had to do with the constitutional issues, and the lower court did make the decision in favor of the patients and physicians finding that privacy and dignity protected this choice as a matter of state constitutional law. The case went to the Montana Supreme Court, and the Montana Supreme Court, as courts sometimes do, said, we don't need to reach the constitutional issue, constitutional avoidance, because we can decide this on statutory grounds. What the court said was, what the Supreme Court said was, in Montana we have a statute called the Rights of the Terminally Ill Act. That statute is the Montana Advance Directive statute, which empowers people to make their wishes known. And what the court said is, that statute reflects that it is the policy of the state of, I almost said Vermont, the policy of the state of Montana to vest autonomy in individuals to make their own end-of-life decisions. That's the policy of this state. We empower our citizens to make their own end-of-life decisions. Therefore,
That's my question.
okay, therefore, it would not be permissible to prosecute a physician who provided aid in dying. That would be against the public policy of the state.
My question, though, is, have you seen any provision in the Vermont Constitution which would correspond to the being made of the Montana Constitution?
I can't say that I've looked. I don't know. I don't practice here. You know, obviously there's not a litigation pending. Whether there is a basis to bring that kind of claim here. I know that Montana is alone in having the dignity clause. It's certainly not alone in having a privacy clause, but I don't know the particulars as to Vermont's constitution. But again, the ruling in Baxter was statutory. And one of the things I wanted to share about Baxter, since we're on the subject, which I think is important to note, is that in the wake of the Baxter decision, and one of the speakers this morning had talked a bit about Board of Medical Examiners. The medical board in Montana, in the wake of Baxter, has adopted policy around the practice of aid in dying and basically normalizes the practice. What the Montana Medical Board says is, if we receive a complaint about a physician providing aid in dying, we will handle that complaint as we would any other medical practice or procedure, which I think is appropriate. It's basically normalized the practice within the practice of medicine. And I think that is where we are moving.
Thank you. Appreciate your time
Thank you
with
so
us.
much.
Thank you for coming.
Enjoyed being
You
here.
live in Los
On
Angeles?
this beautiful snow. Yeah, I know I haven't seen snow. I am a New Englander, I want to
Oh,
say,
okay.
originally, and I have a student at Dartmouth, so I feel like I'm a little bit of a local, and
Good.
enjoy the snow.
Well,
So,
enjoy the snow.
yeah, thank you
Doesn't
so
snow
much.
in Los Angeles.
No, it does not.
Thank you.
Thank you very much.
Our final witness today will be Norman Smith, who's an attorney. And I appreciate you being here. We're not going to have time for the gentleman from Oregon to hear